Greetings everyone, my name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com, and today I need to talk about yet another copyright infringement lawsuit brought against a YouTuber. I used the word need pretty carefully there. I actually had a different video planned out today. It was going to be about this guy, the ST key for the Sega Saturn. Pretty interesting piece of hardware that was used to circumvent region locks on the Sega Saturn that was completely legal when I bought it in 1996, but became legal soon thereafter due to the Digital Millennium Copyright Act. Got a great video I want to do about it, but unfortunately it's going to have to wait. This, it seems, is going to take precedent. Now, the lawsuit I'm talking about today involves YouTuber Louis Bond, who goes by the name Chriswell on YouTube. He was sued on March 9th by Serendip LLC. Serendip LLC represents the rights to the works of one Wendy Carlos, who did the score for two Stanley Kubrick films, A Clockwork Orange and, if I remember correctly, The Shining. Now, the reason that's relevant is because on February 20th, this is all according to the lawsuit, by the way, and for the record, once again, I have downloaded the lawsuit and made it available in the description. Feel free to grab your own copy and follow along with me if you see fit. But anyways, on February 20th of this year, Bond uploaded a video entitled Stanley Kubrick, The Cinematic Experience. It's a 20-minute sort of exploration of Stanley Kubrick's work, including pretty much all of the films, and sort of looking at the symbolism and focusing on the details of some of the shots and some of the codas that comes up in his filmmaking. Not much of a film buff myself, but I really enjoyed it. It was a pretty cool video. On the 21st, just a day later, Serendip LLC filed a DMCA takedown notice. Now, this is interesting because it was not a content ID strike. It was a full-fledged DMCA takedown notice. This means it was a copyright strike on Bond's account, which also explains why when he re-uploaded it, which was a terrible idea for reasons we'll get into in a minute, he uploaded it to a different channel. Now, 2 days after the DMCA notice was filed, Bond filed a DMCA counter notice the 23rd. And that means the lawsuit was filed just about 14 days after the counter notice, and that's important. Now, to understand a little bit about this, we have to look briefly at the DMCA process. Let's say you, good sir, or ma'am, I'm not here to make judgments about who you are. You uploaded a video that I personally think is copyright infringing. I would file a DMCA takedown notice if I was not using the Content ID system. You, in turn, could file a DMCA counter notice. Now, two very important things happen when you file a counter notice. First is that you submit to the jurisdiction of a federal court here in the United States. Now, if you live in the United States, that process is pretty straightforward. You're going to submit to the jurisdiction of whatever court is nearest to you. In my case, that would be Southern Louisiana. However, in the case of Bond, he is located in the UK. Now, according to YouTube's rules for filing counter notices, he has to submit to the jurisdiction of the court in which YouTube is in. And YouTube is, of course, California, which makes it pretty interesting. I'll pull this back up again. You can find the lawsuit was filed in the Southern District of New York, coincidentally, the same district that the H3H3 lawsuit was filed in. But the point of this is simple. There's a potential jurisdictional issue there that we'll probably have to explore at a later date when we hear more about as this lawsuit unfolds. However, they had to file that lawsuit if they wanted to keep the video down. And the reason is this: when you file a counter notice, my options are to either A, within 10 business days, which if we're not there are no holidays involved, it's basically 14 days, I have to file a lawsuit in order to keep that video offline, or any other content that's subject to a DMCA notice. If I do that, then the content stays offline pending the resolution of the lawsuit. Now, that's what I believe is really the crux of this. I understand why Bond is concerned, and he certainly has every reason to. The lawsuit does indeed mention damages. But this really doesn't seem to be a lawsuit about necessarily getting those damages. And I say that because, once again, Bond is in the UK. Even if there is no jurisdictional issue within which court this was filed in here in the U.S., which, once again, I'm a little bit skeptical about, but that's just me. Once again, I never bet on litigation for all the obvious reasons. The fact of the matter is, if they got a judgment against him in the U.S. for damages, they would then have to take that judgment to the U.K. and then have a U.K. judge approve those damages and then help collect them. And I'm not saying that Bond is or is not wealthy. I don't know much about his financial status, but it's very unlikely to be worth going through the international headache of collecting those damages, especially in the case of a one-off alleged copyright infringement such as this. But that brings us to the next question. What is the copyright infringement? Well, as I said, the cinematic experience is a 20-minute, I would say sort of a documentary-style video about Stanley Kubrick's film. And according to the lawsuit, and here's a highlight passage from it, in addition to other music from Kubrick motion pictures, the video utilizes an aggregate of about 3 minutes of music taken from the soundtrack of the motion picture or an album of Wendy Carlos' work, the title music, including title music from Clockwork Orange, a march from Clockwork Orange, and the William Tell Overture, representing a substantial amount of those works, ranging from 18% of a 7-minute to 45% of a 2-minute 20-second work. Those are definitely fairly substantial portions of the work. But the question is this: is it possibly a fair use? After all, this entire video was about commentary and criticism of Stanley Kubrick's work, mostly just commentary. Is it a fair use or not? Well, I don't know. And I got into this trap of the H3H3 lawsuit where I spoke too strongly about it almost certainly being a fair use. Once again, my gut says yes, but honestly, the more I think about this lawsuit, the less sure I get. And the reason is, and if you go back to my follow-up on the H3H3 lawsuit, once again, link will be in the description, I talked about a case involving the Elvis Presley estate and a ginormous multi-DVD set of Elvis Presley documentaries. Those documentaries were comprised of 5 to 10% footage owned by the Elvis Presley estate that was unlicensed, and even though they talked over it, even though they added commentary and criticism to this, the courts ruled the use of the footage was not a fair use. That's pretty harsh in a way, but it also makes a lot of sense, because one of the ways in which these videos are used and monetized in 2016 is that they are licensed to documentaries of various stripes, and there's definitely a market for licensing music for documentaries. Proof of that is in the Happy Birthday to You lawsuit. Now, we all know the ending of the Happy Birthday to You lawsuit was that Happy Birthday to You, Warner Chappell Music was forced to drop its claim to it, effectively leaving it with no claimant to the copyright. And so while I'm not going to be naive enough to say that means it is in the public domain, it means functionally it is in the public domain. But however, the reason that lawsuit got kicked off was because a documentary filmmaker wanted to use Happy Birthday to You in a documentary about Happy Birthday to You, and Warner Chappell still compelled her to pay thousands of dollars for a license to use it. So yes, this type of thing does happen. And there are a lot of tough questions about fair use here. However, if I were Bond personally, I would be worried less about the damages in this case. The reason the lawsuit was filed was because of that counter notice. Once Bond filed a counter notice, the clock started ticking, and Serendip LLC, which I still don't understand that name, only had 14 days, 10 business days, in order to either file a lawsuit or just accept that the video would be restored. They opted to file a lawsuit. Those lawsuits are extremely, extremely rare, but they do happen, and it is a real risk. I think, honestly, that's the main crux of this. Now, the issue at hand is this. Bond has to respond to this lawsuit, basically, because if he doesn't, there's going to be what's known as a default judgment against him, which A, will definitely result in a permanent injunction against the video being re-uploaded, but also could result in damages against him, and it could be possible, given the fact Serendip LLC has already taken the unusual step of filing a post-counter notice lawsuit. They might be aggressive enough to go ahead and just take this matter to the UK and collect their damages that way. So, yeah, it could happen. All in all, this is a pretty interesting and pretty unusual case. I don't know how worried I am about this. The facts of the case are fairly unusual with YouTube, but it does and it should give YouTubers a moment of pause when they consider filing a counter notice. If the fair use is not extremely clear-cut, a counter notice may not be the wisest course of action, even if you do believe that your use is legal for various reasons. So, yes, this is going to be another one to watch, and I'm already watching the H3H3 lawsuit, so what I've done is I've modified my filters. I will be getting updates about this one as they are posted to Pacer and to other sites, and we'll continue to talk and update you about them here. all in all, that's about all I can share with you this week. It's a pretty interesting case, but it's also kind of a fairly straightforward copyright dispute in many respects of the word. So, on that note, everyone, thank you very much for your time. Once again, I appreciate all the new subscribers, all the new help I've been getting, and all the new encouragement. Really appreciate it. Definitely feel free to subscribe, share, send these videos out, like, thumbs up, all that jazz. And until next time, this is Jonathan Bailey, signing off.